Please, madam. The bunch of cases, madam, these are listed on my application seeking permission to declare the result. But essentially, what the petitioners are claiming in these bunch of petitions are, madam, that they are contractual employees working as sub-engineers. Now, madam, we have floated an advertisement for regular appointment of sub-engineers. Now they say, madam, that their services should be regularized, and without regularizing their services, direct appointments cannot be made. Others were pleased to pass an interim order directing that the results will not be declared. But I am for the agency, my lord, who has conducted the examination. State has also filed a picketing stay. Okay.
Maharaj, may kindly see. Firstly, Maharaj, this application may kindly see. Who has filed this application? An agency who has conducted the examination, and the agent, Maharaj, may kindly see this application. A paragraph 3 may kindly be seen. It is most respectfully submitted that the main relief claimed by the petitioner is that the petitioner should be considered for regularization for the post of sub-engineers, and such this relief can be extended by the answering respondent. Now, kindly see, he said, and post of sub-engineer, and such this relief cannot be extended by the answering respondent. It is further submitted that the answering respondent is entrusted with the responsibility of conducting the examination, which has been successfully completed. However, in compliance of the interim order passed by this honorable court, the result has not been declared. It is submitted that this entire process of appointment has been stalled because the result has not been declared by the answering respondent. It is submitted that the answering respondents adopt the reply filed by the state government in the instant petition, if any, as the main relief. If any, they are not sure, as the relief claim, relief of regularization claimed by the petitioners cannot be extended by the answering respondents, and thus praise that the interim order should be vacated so that the selection process could continue and the results can be declared. Now, the examining agency, the relief which we have claimed in this petition is against the state government. We have challenged the advertisement issued on behalf of the state government, the process of selection undertaken on behalf of the state government, the rules framed by the state government. And the examining agency says that they say we cannot grant the relief. At the same time, they say that the stay may be vacated without filing any reply on merits of the case. Now, Lords may kindly see the reply which the state government has filed in this case. The state government has not cared to look into the pleadings filed by the petitioner. They have not answered the issues which we have raised in the petition. They have simply adopted. Maharaj may have a look on the reply filed by the state government. They have not replied to the contentions which we have raised. In my case, Maharaj, in this case,
Maharaj, the copy of that is not supplied to me. I know 7.3.
And in other cases, the replies have not been filed. It's only one case now the reply has been filed. They have not filed the reply.
The copy has been supplied.
Why are you opposing declaration of results?
Maharaj, we have...
Have you participated in this?
Yes. For the reason being, my lord, the entire process is polluted. My lord, kindly see. We have 73% posts are reserved, my lord.
That's not right.
And, my lord, what has happened, my lord? This same examination was held earlier. We had appeared in the examination. Out of that examination, they prepared a merit list. In the merit list, the persons who were at the top, they were given regular appointment. The persons who were low in the merit list, they were granted the contract appointment. Same process they have again started. That was also regular. That was for, no, it is like this or this only. We have said that. How many times
The state is also not coming forward that they want to make the appointments. It is the application only from the side of the examination agency.
We are still not that 2,500 appointments are to be made.
State,
You have not make a submission.
State has
not filed any application.
आपने रिप्लाई नहीं दिया सारे केसों में.
Commission may make a mention. May make a commission.
Circular on the for petitioner, the relying my lord only provides for 20%. Their appointment order contains a stipulation my lord when they were appointed or contracted. Apart from raising claim, state has taken a policy decision my lord to reserve earmark 20% post for the contractual employees already working. They have been granted age relaxation of 10 years my lord, and a 20 contest. There cannot be a direction to the for direct regularization. Will not the issue stands covered under the division directly against the petitioner on the same issue.
Yes.
And earlier the division bench has considered this aspect. My lords may just have a look, my lord, on this.
The petitioners have not appeared in the examination. What my respectful submission is.
What is the judgment?
Lord, this judgment is not regarding the same issue, not where there was 25% reservation, not for the existing, but not people who've been regularized. If your lordship may kindly see, the single bench stated that despite there being not this provision, not for recruitment by advertisement, not the single bench stated that first people who've been working on contractual basis have to be regularized first. Only then, by virtue of an advertisement, it can be taken up. Now, this is the division bench judgment upholding the learned single bench judgment.
Yes, it has to be considered.
Yes, sir. So, all we are saying is, the right is created. In these cases, the entire advertisement process was stalled, saying that you cannot proceed with recruitment or advertisement. And the learned single judge stated that unless the people who are working on contractual basis are regularized, you cannot take up direct recruitment process by way of virtue of an
This is directly not in converse.
Yes.
So, the learned single judge as well as the division bench stated that the advertisement process would be taken up further only when people who've been working for more than 10 years in light of Uma Devi would be regularized first. This is what...
Are you being terminated now?
We are not being terminated, but these people would be our seniors, and these people
are working.
We are working. We are contractual.
Will all be subject to orders of the board.
By appointments will be made and the difference.
Once the
We are not subject to orders. We are working on it.
once the
Continue to work.
once my lord, the appointments are made. Once the appointments are made, my lord, then my lord, because they have earlier they had an examination.
All appointments have to be made.
My lord.
We have also claimed for relief
This
there.
stalling processes like your interest also has to be protected, isn't it? So that they are already saying that they are not terminating you. So for the present, ultimately an interim order is an equity for both, not one-sided. So if your interests are being protected, for the present you should not have a grievance. The question of termination, then we understand.
But simultaneously they can...
They are saying that they are not terminating. They are
Paragraph
not
9 of my reply.
My lord, my humble submission is this, my lord, that the very process which they have initiated.
That we have to decide that.
My lord.
You have to decide that. So now, as an interim measure, you need to be protected.
My lord.
Correct. Not that you are being ousted or you are being sent out. So that ultimately an interim order is to balance both sides. For that reason, we have
So just one difficulty, if I may just voice my application. Few people have participated in the process, few have not, who've been working for more than 15 years in the department. Now the difficulty is that only 20% reservation is done under the advertisement. Now there are more than 1,400 employees who are contractual employees, and the vacant posts are far less. The people who approach this honorable court, my lord, are more than, my lord, 200 in number. In fact, my lord, the number would be nearly 300 petitioners before him. So that difficulty which is created, my lord, they may declare the result, at least the appointment will not be made, my lord. They may declare the result and any date be fixed, my lord, because it's squarely covered by the two division bench judgments, my lord, of Indore bench and Jabalpur bench. We were praying it can be heard early, my lord. So that otherwise, my lord, difficulty would be few have participated, few have not. Yeah. So even contractual employees have participated. So the question of seniority would come in. And people who are direct recruitees, my lord, would be treated to be senior, my lord, to the people who are working for more than 15 years in the department. Yeah. That's the difficulty, my lord.
No, we don't see any difficulty. We are all subject to the result of
one more relief we have claimed, ballot. That they should give some wages to us for working for 10 years, 15 years, 20 years in the same process, ballot. Which they can do.
Dated 11/5/2022 in WP 8612 of 22. By way of an interim measure, it was directed that the respondents may continue the selection process pursuant to Annex of P12, but no final result of the post of sub-engineer shall be declared without the leave of this court. Selection process continued thereafter. The examinations were held. The results have not been declared. Therefore, application number so and so cases have been filed seeking permission to declare the results. An application so and so has been filed seeking to vacate said interim order. Similar interim orders were passed in WP. Which are the cases?
All the 186
remaining petitions by following the order passed in WP 8612 of 2022. The application filed by the state as well as
Professional Examination Board, respondent
the Professional Examination Board, to the effect that the selection process cannot be stalled in view of the large number of how many vacancies are there?
2,500. 557. 2,557.
2,557 posts. That the state in their affidavit have also stated that they would abide by the instructions issued by the government from time to time. And therefore, at present, there is no proposal of the government to remove such persons who are working on contractual basis. The petitioners are persons who are working on contractual basis. The statement made by the state is to the effect that there is no proposal to remove such persons working on contractual basis. Therefore, we are of the view that larger interests of justice and equity, and in view of the fact that the petitioners are not being removed from their contractual appointments, it's only just as necessary that the respondents be permitted to declare the results. The declaration of results and the further processes will all be subject to further orders of this court. IA for vacating stay and permission to declare the results are accordingly disposed of.
Before making any appointment, the petition can be heard finally.
The contentions of the petitioners regarding the action of the respondent will all be subject to further orders of this. The further appointments, if any, to be made by the state will also be subject to further orders of.
My lords, if possible, my lords may kindly observe that in the meanwhile they may consider our cases for regularization, my lord. They should not construe as a.
In the impregnum, the state may also consider the case of the petitioner for regularization in accordance with.
But regularization the claims are already rejected.
They have said in accordance with.
But they are already rejected.
Item number 45 is identical, my lord. It was listed yesterday. My lords were pleased to direct for listing today, my lord. Item number 45.
One minute. 40?
45. 45.
Common order schedule. Same order at 45.
My lord.
I am making an oral prayer, my lord,
Declaration.
in 7.31.
Now, this case, my lord, this petitioners, they had appeared for.
What is the default?
For the default, my lord, the territorial jurisdiction objection has been raised in respect of, my lord, 5 petitioners on the ground that, my lord, they are the resident of the places which fall within the jurisdiction of the, my lord, Gwalior bench and the Indore bench. Now, my lords may kindly see, my lord, the objection is raised on the ground of their place of residence. Under 226, my lord, place of residence never decides.
The office objection on place of residence of petitioners number?
My